the committee will resume its public hearings on Bill 142, an act to enact the Consumer Protection Act 2023, to amend the Consumer Reporting Act, and to amend or repeal various other acts. I will now call upon our first presenter, Nina Deeb. Please state your name for the record, and then you may begin. You will have 7 minutes for your presentation.
Good afternoon, Chair and committee members. My name is Nina Deeb. I am a full-time real estate broker, and I have been since 1996. On Bill 142, the Consumer Protection Act, consumer protection was delegated to the development industry called HUDAC in 1976. This was packaged to buyers as a benefit to them. The buyers would now, by law, have a warranty with their new home. The buyers had no choice. They had to pay the development industry for their protection. The buyers shifted this mandated cost to the buyer's legal bill. Buyers now have two delegate authorities taxing costs onto their legal bills. When buyers buy a condominium, they have a third delegate authority to pay recurring monthly fees to. Terrion holds $702 million in reserves, yet they found it necessary to increase their ceiling warranty fees by 333%. Organized real estate in Ontario consists of 40 tax-exempt corporations. The CEO of the Ontario Real Estate Association was the Minister of Consumer Services that introduced the Consumer Protection Act in 2002. It specifically does not apply to consumer transactions for the purchase, sale, or lease of real property. The Act also does not apply to this 101-year-old organization that recategorized health insurance as dues in order to increase their fees by 700%. UREA has 70 employees and is attempting to collect over $1 million per employee by mandating health insurance on membership. Health insurance has nothing to do with selling real estate. The industry is currently severing buyer representation. It claims to be increasing choice for buyers. Buyers do not pay for this representation, the builder does. When consumers do a job themselves, they do so to save the cost of the service. The regulatory change saves the builder the cost while eliminating the buyer's representation. There will be no savings to the buyer. This serves developers and will save them over $1 billion a year. This is not a practice that all builders will embrace. Corporate builders through agency can sometimes pay $300 for a new home sale. The CPA specifically excludes a home purchase. The real estate and development industry offered their own private corporations for dispute resolution. This is a $2 billion a year franchise of government authority to the development industry to run court quasi-judicial substitutions of their own. There's no equality of power between corporations and individuals. The emission of protections for housing participants made economic space for 14 private corporations to sell mandatory warranties, insurance, registrations, and consumer co-payment charges. These corporations produce nothing. They're advancing sector-specific protection measures while claiming to be protecting the public. If one fails, it could deploy one of their other authorities through legislative duplication. This was the testimony of John Roberts, a retired Terrion Enforcement Director. Former Ministry of Government Consumer Services and Common Sense Revolutionary operators make up the executive composition of these government replacement corporations, including ministers of MGCS, Solicitor Generals, and Ontario's former Deputy Solicitor General, among others. This bill proposes to introduce amendments regarding those that make false claims of government oversight. The delegate authorities choose names that lead the public to believe they are the government. Hot water heaters by aggressive sales tactics. New home buyers have no choice in whether they have a rental hot water tank installed in their home. Corporate builders force hot water tank rental contracts as a non-negotiable part of their home package. The builders I worked for did not practice this. Buyers could purchase a hot water tank and have it installed in their new home. I worked for fantastic builders. The builders I represented always met closing dates. If buyers took the time to purchase their fixtures and updates, the builder would have the plumber or electrician install their fixtures. They had heating units in the homes, but the builder would sometimes use the furnace and air conditioners in the model homes. Extend enforcement powers to cover the actions of the intermediaries like the billing agency. This bill proposes to extend the Crown to those corporations to use the government authority to collect funds. The Crown must not be made available for private corporations. The government must preserve, respect, and use of the Crown. These development industry corporations, through many regulators, have the power to bankrupt consumers, advocates, and critics. OMVIC collects fees from all three participants of a car purchase. TECO received taxpayer funds for the past 3 years and has been lobbying for the power to charge co-pay fees from consumers. According to the Ontario Auditor, between 2015 and 2019, the ESA collected $17 million in inspection fees for inspections that did not actually take place. Within 1 year of the expansion of powers of the Condominium Authority Tribunal, 6 condominium residents died. The idea to delegate power to private corporations for profit has resulted in devastating outcomes for individuals in volunteer positions and for consumers. The Minister of Consumer Services that
1 minute
created
left.
OMVIC, TECO, and RICO is on the executive board of Tarion and OMERS. He was the registrar and the CEO of the Ontario College of Trades. The Minister of Consumer Services that excluded housing from protection is the CEO of the Ontario Real Estate Association. The ministry says it would like to hold bad actors accountable. The bad actors are the politicians and former civil servants that are still developing a shadow government. Who protects consumers when they have complaints regarding the development authorities? In 1920, the real estate and development industry began as one association. This group of organizations is now 108. Consumers of housing do not have equal opportunity with the entire development industry. It would be highly inappropriate for more former MPPs with consumer protection posts to be appointed to these executive councils. Fast forward 20 years, see the executive boards of Tarion, HCRA, OMVIC, BAO, RICO, CAO. In conclusion, I would like to say I find that this bill is, it goes in, it's in the
Thank you.
face.
That's all the time that we have for this round.
Ms. Deeb, I was reviewing your written submission again, and you have a paragraph on the first page that talks about OREA and health insurance. And I'm just trying to figure, maybe I missed this in your presentation, but I'm just trying to figure out how that's relating to the bill.
The reason it relates to the bill is because anyone working in a professional, so it actually doesn't apply to people that are working. So if you're working, the CPA doesn't apply to you. So as an individual, so my professional organization, which is a nonprofit, can increase their fees 700%. And I have no consumer protection on that. Like, it's been in the papers.
Sure, yeah. So you're suggesting that your relationship with OREA is one of, as a consumer, you're purchasing something from them as opposed to a member of an association.
It's mandated on us. It's not just a purchase. If we don't purchase this health insurance from OREA, we will lose our livelihood December 1st. So this is mandated. It is a $65 million mandate.
Yeah, no, sorry, yeah.
So I don't blame the first two presenters for coming here today and talking about home purchases. In fact, for people that purchase a home, it's usually the largest purchase they ever make in their life. And for a government to come forward with consumer protection legislation and revamping, as they say, the consumer protection system, and to omit homes as part of that, I can understand why you would be here asking about it. I raised the very same question to the minister this morning, asking why that was not included, and I was told, or directed rather, to the HCRA, saying consumers are protected when they go there. Simply stating, do you feel that the delegated authorities, HCRA and Tarion, are providing that strong consumer protection today for consumers? Not.
I think any of the delegated authorities are working as they should. There's been complaints since 1976, but the governments throughout the next 47 years carried on with installing these organizations. I think that the industry lobbied for these organizations and it was awarded to them. Also within this legislation, like what I see here proposed, is I see fines going up. doubling. So these are fines going to private corporations that don't pay taxes. I don't see how that's helpful. We shouldn't be giving them more money. Like, they have billions of dollars in reserves. I don't think we should be permitting them to be increasing their fines. And also, they don't require evidence for their fines. You don't actually have to commit an offense. You just have to think about it, or it actually has a clause in here that says you don't have to have committed the offense, that you could have done everything in your power to not have contravened the act, but you'll still be guilty. So I know there's some lawyers here, I question that type of law.
Okay. And at the time, just like when I asked about consumer protection with regards to home protections for new home buyers, I was told that, well, we have a series of delegated authorities in a number of different areas that are providing consumer protection in many ways. I mentioned the HCRA and Tarion, and there was mention even about questions about board makeup and whatnot. In a more broader perspective, do you believe that the host and the many delegated authorities across Ontario right now are delivering a gold standard of consumer protection in the different areas? Ms. Deeb, any comments on that?
I have studied all the delegated authorities, and I originally wanted to make repairs. I thought they were salvageable, but the delegated authorities, this is not a salvageable system. The government must take its authority back. It must rescind its agreements, its administration agreements. These corporations do not permit me to engage in their annual general meetings. So for someone to pay attention and to say, I read their annual reports and they actually don't permit public engagement, you can't even ask them a question at their meetings. So my response is that I don't think they're correctable. I think we have to rescind the authority. Thank you for the question.
Okay, thank you.